Thank you everyone for joining us today. My name is Kent Law. I'm from the Committee of the Queensland branch of the Australian Association of Constitutional Law. I'm very excited today about today's event about Canadian developments in constitutional law and as human rights law as well. Lindy and I have been scheming about this event for a little while now. So just at the outset, I should let everyone know today's event is being recorded by the AECL. Without wasting any more time, I'll introduce you to the chair. Stephen Keim of his senior counsel was called to the bar in 1985 and took silk in 2004. He has a very broad practice and has worked in most areas of law. He has appeared for the plaintiffs in the High Court in the case of Love and the Commonwealth. And he's also appeared in a number of other constitutional cases, including Spence and Queensland. And I believe he appeared in the High Court just yesterday. So thank you, Stephen. Over to you.
Thank you, Kent. Hello, Canada. Hello, everybody. Welcome to the Australian Association of Constitutional Law, Queensland chapter, seminar on Canadian developments in constitutional law and human rights. I'd like to begin by acknowledging the traditional custodians of the land from which we are streaming today's seminar. In Meanjin, Brisbane in Australia, we pay our respects to both the Jagera people and the Turrbal people and their elders, past, present and emerging. In Te Otikake, Montreal in Canada, we pay our respects to the Kanyen Kahaka people and their elders, past, present and emerging. It is appropriate that Australians interested in both constitutional law and human rights should look to the Canadian experience. If one leafs, as one does, through William Harrison Moore's 1902 edition of the Constitution of the Commonwealth of Australia, you will notice that the learning from which he draws to discuss the newly minted Constitution draws as often and as much on the United Kingdom statute, then known as the America Act of 1867, now known, as I understand it, as the Constitution Act of the same year, as he does on other examples such as the United States Constitution. Indeed, the Canadian example shone brightly from soon after the inkling struck Australian colonial statesmen and politicians and the secretaries to colonies in London, that the colonies for whom they spoke had shared problems that could only be solved by some body that was bigger than them all. In the human rights field, the Charter of Human Rights and Freedoms forms the first part of the Constitution Act of 1982 of Canada and was preceded by the Canadian Bill of Rights enacted in 1960. Indeed, for those of us in Queensland coming to terms with our homegrown Human Rights Act 2019, one of the most commonly issued phrases that issues from our mouths is, what does the Canadian jurisprudence say about that? Often we say, what does the Canadian jurisprudence say about that, Kent? So it is only appropriate that our speaker today, Lindy Ruia-Labe, is a distinguished lawyer working at the Department of Justice Canada and its Quebec regional office. Lindy has experience in the areas of constitutional law, Aboriginal law, administrative law and civil litigation. Lindy's educational background includes a Bachelor of Arts Honours, an LLB gold medalist from the University of Quebec in Montreal and an LLM from Stanford University. Prior to starting her career as a lawyer, Ms. Ruia served as a law clerk to Justice Fish in Australia, Canada, 2009 to 2010. Lindy has represented the Government of Canada several times for various Canadian courts, including the legal challenge against an aspect of the medical assistance of the Canadian Parliament, known as the Truchon litigation, which is one of the cases about which Lindy will speak in her presentation today. I can also say that Lindy also worked at the Cambodian War Crimes Tribunal in Phnom Penh for the prosecution, where she led the convener of this seminar, Kent Law. So the seminar has been a conspiracy between them going back at least a decade. This is the Truchon case is one of the cases about which Lindy will speak. There have been a number of fascinating pieces of litigation troubling Canada's higher courts, and some very interesting legislation being passed by its parliaments, all of which have learnings from which Australia can draw. The program is that I will stop speaking soon. Lindy will then speak for about 40 minutes. Then we'll have 10 to 15 minutes for questions. So please write down some thoughts to share with us at that time. To share your questions, you can either use the chat function with the link here, here. Alternatively, you have to put your albeit artificial hand up. And then after some very interesting discussion and questions, the aforementioned Kent Law will officially close the seminar, hopefully not too far past the hour. So without any more ado, it's my great pleasure to introduce you to our speaker today, Lindy Rouillard-Labé. Thank you.
Thank you, Stephen, for the kind introduction, and congratulations on pronouncing my name right. And thank you, Ken, for organizing this event today. Before I start, I would like to begin to sorry, by acknowledging that I'm talking to you today from Montreal, a land that formed part of a traditional territory that has long served as a place for many Indigenous peoples, including the Kanien'kehá:ka, to live, meet, and exchange. And I also want to make a disclaimer that the opinions that I will express are solely mine and not those of my employer, the Government of Canada, or the Department of Justice. I will share my screen. So you should be able to see my PowerPoint presentation. If there's any issue with the sound or the PowerPoint slides, please don't hesitate to let me know. With that said, we can now delve into Canadian constitutional law. Okay. So what I propose to do today is first go through some general principles of Canadian constitutional law, and then address three of what I believe are the main topics in Canadian constitutional law at the moment. First, federalism. Second, the protection of human rights. And third, Aboriginal and treaty rights. And for each of these topics, I intend to give one example of recent developments. If I have time, and I hope I will, I would like to say a couple of words at the end about a recent case on amendments to the rules of succession to the British throne. Okay, let's first start with a quick introduction to Canadian constitutional law. Like Australia, Canada is a former British colony. It was, in fact, first colonialized by France, which explains, well, first my own accent, but also the fact that Canada, there's a French minority throughout the country, and there's also one province, the province of Quebec, where the majority of the population speaks French. Unlike the US, Canada's independence from the United Kingdom is not the result of a revolution or a war. Canada's independence was gained is a result of a gradual process in the 19th and 20th century. And this explains why there is not in Canada just one single document that contains all constitutional law rules. There are multiple instruments that contains constitutional law in Canada, and I listed here on the slide that you see three of the main instruments of Canada's constitutional law. First, the Constitution Act of 1867. It's a statute that was adopted by the United Kingdom Parliament, and it created the Dominion of Canada, which enjoyed considerable degree of self-government, but still was a British colony. But importantly, that statute, the Constitution Act of 1867, established the rules of federalism, so the division of power between the federal parliament and the provinces. The Statute of Westminster of 1931, to which you're probably familiar. It's an important step in the accession of Canada to full sovereignty. But it's only in 1982 that the authority of the United Kingdom over Canada was completely terminated. In 1982, Canada patriated its constitution. It added a new amending formula, so it terminated the involvement of British Parliament in amending Canada's constitution. And up until that point, up until 1982, the protection of civil liberties was left to legislative bodies or the rules of common law. But this changed in 1982 because Canada adopted, as Stephen mentioned, the Canadian Charter of Rights and Freedoms. The Charter is part of Canada's constitutional law, so it can only be amended following the amending formula, and most importantly, courts can invalidate statutes, federal and provincial statutes, that are in breach of the charter rights. Here's a map of Canada today. So Canada is now constituted of 10 provinces and 3 territories. The territories are located in the northern part of the country, and they're inhabited by in large parts by Indigenous peoples. For the purpose of today's discussions, there's no need of distinguishing between provinces and territories. They basically have the same constitutional powers. Okay, first important topic in Canada's constitutional law is federalism. I start here with a quote from a recent decision of the Supreme Court of Canada. In this quote, the court first recognizes federalism as a foundational principle of constitutional law in Canada. The court also says that federalism is a result of a compromise at Confederation. So in 1867, sorry, it's a compromise between local interests and the need for unity across the country. And in Canada, the Constitution, the 1867 Constitution Act, allocates exclusive powers to each level of government. So exclusive power to the federal government and the provincial governments. There are no concurrent powers in the Constitution. But despite that, the courts have favored a flexible view of federalism and a view that encourages cooperative efforts between orders of government. This is what we see from that quote as well. I listed here some examples of heads of jurisdiction that are enumerated in the Constitution Act 1867. We can see that the federal powers tend to be mostly on matters that are national in scope, like navigation, defense, money, while provinces have jurisdiction over areas that require local attention. Provinces have significant legislative powers through subject matters like property and civil rights and matters of local and private nature in the province. That would include health services, education, child welfare, for example. But although provinces have these broad areas of jurisdiction, provinces only have the powers that are enumerated in the Constitution. And in Canada, it's the federal government federal parliament that has the residue of power. So matters that are not enumerated in the Constitution will fall within the federal power through the peace, order, and good government power. peace order and good government, it's derived from the preamble of Section 91 of the Constitution, which I included here on the slide. And the courts have gradually developed a test to identify what matters can fall under that peace order and good government power. And essentially, the courts have identified 3 branches of power that can fall within peace order and good government, what we call POG power. So first, matters of national concerns. I included examples here of matters that now fall under the matters of national concern branch. For example, aeronautics, development of the national capital region, the control of atomic energy, control of marine pollution. Second branch of the POG power is the emergency power. So the federal parliament can enact legislation to address emergency, for example, wartime measures or the reduction of inflation, some measures that were adopted in the 1970s. The third branch of the POG power, it's the gap branch. So the federal can use its power over peace order and good government to fill out some gaps in the distribution of powers in the Constitution. I would now want to look at a recent decision of the Supreme Court about the peace order and good government power. And this decision is about an act that was adopted by the federal parliament in 2018 about greenhouse gas pollution pricing. I'll say a couple of words about this act before turning to the Supreme Court decision. So this act establishes a pricing scheme to impose charges on fuel and excess emission of greenhouse gas. Mainly, it has 2 parts. The first one directly prices the emissions of certain fuel producers, importers, and distributors. And the second part applies to larger emitters of greenhouse gas, and it imposes charge to them to their greenhouse gas emission if these emissions exceed the applicable efficiency standards that is defined, standards that are defined in the regulation. There's a couple of important points to understand how this act functions. It's a bit, the act is a bit technical, so I'm trying to make it understandable here, but there's, I think, 2 important points to understand how this act functions. First, it doesn't set a cap on emission. So what it does is it imposes charges on greenhouse gas emission, charges that are incorporated into the price of fuel or the cost of industrial activity, what the act does is it tries to induce changes in the behavior of individual consumers or businesses, hoping that these changes will lead to a widespread reduction in greenhouse gas emission. That's the first element of this act that I wanted to point. The second one is that the act sets minimum pricing standards. So these standards, the federal standards, will only apply in a province if the province did not itself have sufficiently stringent pricing standards. So the federal acts gives flexibility to the provinces to enact their own greenhouse gas pricing scheme, but it ensures that there's a federal backstop that will apply if the provinces do not meet the federal benchmark. This is a novel approach in Canada, like the federal government imposing minimum standards that applies only if the provinces don't meet the standards enacted by the federal. Currently, there are 8 provinces and territories that are subjected to the federal benchmark. So basically these 8 provinces and territories are considered by the federal government not to meet the federal stringency requirement. So this act was enacted in 2018 by the federal parliament, and it was challenged by 4 provinces. through three of which were references to Court of Appeals, and this all led to a decision of the Supreme Court in 2021. In its decision, the Supreme Court decided that the federal act was valid through the national concern branch of the peace, order, and good government power I discussed earlier. What's important here is that the regulating emissions of greenhouse gas would normally fall within provincial powers. But the court here recognized that pricing greenhouse gas emissions cannot be done at the provincial level, and that it requires a national initiative because the effects of greenhouse emissions are not confined by borders, and failure of one province of enacting a sufficiently stringent pricing scheme could jeopardize the success of the greenhouse gas pricing scheme as a whole. So we see, I included two quotes here that contain important takeaways from this decision. In the first quote, that is at the very beginning of the Supreme Court decision, the court recognizes the reality of climate change. It's an important and a strong statement from the highest court of the country. So it sends a strong message to lower courts, but also to those who still doubt the reality of climate change. And the second statement, in this statement, the court recognizes the necessity of cross-border initiative to address climate change. And this is why the court recognized that the federal parliament could enact a legislation using the national concern branch of the peace, order, and good government power. I will now turn to the second topic of interest in Canadian constitutional law, the protection of human rights. I mentioned it, I already mentioned it, Canada, the Charter is part of the Constitution, and it expressly overrides inconsistent statute. Courts have, since 1982, at multiple occasions, declared invalid federal or provincial statutes because they infringe on charter rights. However, charter rights are not absolute. There are at least two mechanisms through which legislature can infringe on charter rights. The first one is the override clause, also called the notwithstanding clause. It's possible for a legislature to override a charter right by including in a statute a notwithstanding clause that will be valid for 5 years and can be reenacted. It's been rarely used in the past 30 years, although we see a recent increase by provincial governments in the use of the override clause. The second and most common mechanism to infringe or justify infringement to charter rights is the general limitation clause, section 1 of the charter. And this clause allows legislature to justify a statute that infringes on charter rights. And the Supreme Court has developed a test to determine whether an infringement is justified. And in summary, the government has to prove that the statute pursue a sufficiently important objective and that it impairs the right no more than is necessary to accomplish the objective. And most of the charter case litigation turns around the second criterion, the minimal impairment, what we call the minimum impairment criterion. The government has to show that the law employs the least drastic means to achieve the objective. And we'll see that it was what was at issue in the medical assistance in dying litigation in a minute. On this slide, you see some examples of rights and freedoms that are protected in the Canadian Charter. I'd like to turn now to how the protection of human rights in Canada really impacted on the legalization of medical assistance in dying. The case the first important case is called Carter versus Canada. It started in 2009. The main plaintiff was Mrs. Gloria Taylor. She suffered from amyotrophic lateral sclerosis, ALS. It's a neurodegenerative disease, and Mrs. Carter challenged the prohibition against assisted suicide, which was found in the criminal code at the time. So in 2009 and in 2015, when the Supreme Court rendered its decision, it was prohibited in Canada. Assisted suicide was completely prohibited in Canada. In its decision in 2015, the Supreme Court agreed with Mrs. Taylor and declared invalid the provisions of the criminal code to the extent that they prohibit assistance in dying in Canada to adults who have grievous and irremediable medical condition that causes enduring suffering that is intolerable to them. The Supreme Court found that the prohibition against assisted suicide had the effect of forcing some individuals to take their own life prematurely for fear that they would be incapable of doing so when they reach a point where suffering was intolerable. Sorry. It's 9 p.m. here, so please bear with me. The court referred to this this choice, the fact that they had to choose to end their life prematurely. The court referred to this as a cruel choice that is imposed on people with a grievous and irremediable medical condition. And this is really this cruel choice that led the court to find that the prohibition on assisted suicide breaches the right to life, liberty, and security of those people. And as in any charter cases, the court then analyzed whether the prohibition, whether the infringement on the charter right was justified. And although the court agreed that Parliament's objective, which was to protect vulnerable people, so although the court agreed that this objective was important, the court found that the blanket prohibition against assisted suicide is not the least drastic means. So this is at the minimum impairment criterion that the legislation was found to be invalid. The court said that it's possible for Parliament to design a legislative scheme that would allow assistance in dying and protect vulnerable people. Following that decision, federal Parliament enacted a statute legalizing medical assistance in dying. You see here on the slide the eligibility criteria that were established in that statute. And I want to point your attention most particularly to the last criterion. So to be eligible to medical assistance in dying, according to the statute of 2016, a person had to be at end of life, or to use the terms of the legislation at the time, the person, their natural death had to be reasonably foreseeable. These terms were not defined in the legislation. Their interpretation was left to medical practitioners, and evidence suggested that most medical practitioners saw that as a requirement that natural death be expected within about 6 months, but some of them also extended that to 12 or 18 months. But that was a flexible criterion that was supposed to be interpreted and applied by medical practitioners. There were also safeguard measures. In particular, the medical assistance in dying requests had to be in writing before 2 witnesses. The person had to be assessed by 2 physicians, and there was a waiting period of 10 days between the request and the provision of medical assistance in dying. The 2016 statute was challenged, and particularly what was at stake in the Truchon versus Canada case was the requirement that the person's natural death be reasonably foreseeable. Stephen mentioned it earlier, but I should disclose it here again that I was representing Canada in that litigation. The two plaintiffs in the Truchon case had degenerative condition, but they were not at end of life, so they did not meet the natural, reasonable foreseeability of natural death requirement, and they were therefore ineligible to medical assistance in dying. And they challenged that requirement, and the superior court, so first instance court, agreed with them that the requirement, the end of life requirement, infringed their charter right. Again, the court referred to the cruel choice that this requirement imposed on them, in a way that this requirement compels people, according to the court, this requirement compels people that are not at end of life either to end their lives prematurely when they're still capable of doing so, or to continue suffering until they reach a point where they're eligible to medical assistance in dying. So the court found that the requirement, the end of life requirement, breached both the right to life, liberty, and security, and the right to equality. The court then turned to the justification, whether the infringement is justified. And Canada had provided substantial evidence in the case to try to show that this requirement, this end of life requirement, was justified to protect vulnerable people. Notably, the evidence concerned people with disability, people vulnerable to suicide, and people suffering from psychiatric conditions. But the court concluded that the evidence did not establish that there would be a heightened risk for vulnerable people if the end of life requirement was removed. So according to the court, the physicians are perfectly able to assess the capacity of patients and determine if they are vulnerable or not. And therefore, the assessment of capacity is sufficient to protect vulnerable people. And so the court declared the reasonably foreseeable natural death requirement invalid. Fast forward a year and a half, federal parliament enacted a new statute on medical assistance in dying. It removed the reasonably foreseeable natural death requirement to comply with the decision of the Superior Court in the Truchon case. And so, as of 2021, people that are not at end of life in Canada can access medical assistance in dying. However, Parliament created a temporary exclusion for people who seek medical assistance in dying on the basis solely of medical illness. It's an exclusion that will expire on March 17, 2023. And this temporary exclusion is aimed at giving more time for Parliament to study how medical assistance in dying can safely be provided in this context. Parliament also changed the safeguard measures, since now people not at end of life are eligible to medical assistance in dying. The new legislation creates a two-track approach to procedural safeguards. So individuals whose natural death is reasonably foreseeable, so people that are at end of life, the procedural safeguards are reduced. There's no longer the obligation to wait 10 days between the request and the provision of MAID. However, for people whose natural death is not reasonably foreseeable, so people that are not at end of life, there are additional safeguard measures that apply to them. And in particular, they have to consult with a physician that is an expert in their medical condition, and the assessment, the medical assessment of the request is to last at least 90 days. I turn now to the third and last but not least important topic of Canadian constitutional law, Aboriginal and treaty rights. In the Constitution of 1982, not only Canada included a Charter of Rights, but it also granted constitutional protection to existing Aboriginal and treaty rights. This new provision, constitutional provision, obviously did not create Aboriginal and treaty rights. Aboriginal rights existed and were recognized by common law before 1982. They're in fact rooted in Canada's history, given that Indigenous peoples occupied North America long before the arrival of the Europeans. But the constitutional protection granted to Aboriginal rights in 1982 resulted in a fundamental change to the legal landscape in Canada. Now, federal and provincial laws must respect Aboriginal and treaty rights, and the Crown can no longer unilaterally extinguish Aboriginal rights. The case law is still developing on the constitutional protection of Aboriginal and treaty rights. Courts have developed a test to identify what constitutes an Aboriginal rights. We know that it must be proven on a case-by-case basis, and it usually involves extensive historical evidence in order to show that the right that is claimed by the Aboriginal people is the continuity of a practice, custom, or tradition that was integral to the distinctive culture of that specific Aboriginal people prior to contact with the Europeans. That is the test that was developed by the Supreme Court to identify Aboriginal rights. There are different types of Aboriginal rights that have been recognized by courts: hunting or fishing rights, rights to commerce, and titles to lands, for example. As for treaty rights, they cover both historic and modern treaties. Historic treaties were signed by Canada and Aboriginal peoples from the early 18th century to the beginning of the 20th century, and they were mainly peace and friendship treaties, and particularly during the war between France and the United Kingdom. And also land cession treaties signed in the context where Canada wanted to expand its territory to the west, and there were many Aboriginal people living on that territory. But not all Aboriginal peoples signed historic treaties with Canada, and so since 1975, Canada signed a number of modern treaties that basically they aim at settling claims for Aboriginal rights and titles where no historic treaties exist. Well, I'll come back just if I can. Yeah, okay. One important point that arose from recent case law on Aboriginal rights and treaty rights is that the constitutional protection to these rights is not absolute, and the Supreme Court developed a framework that looks like the limitation clause in the Charter, and it's a framework that allows governments to justify infringement on Aboriginal and treaty rights as long as they show a compelling objective. So, for example, fisheries regulations could be justified even if it infringes on an Aboriginal fishing right of a particular community, if it's in the interest of conservation of resources, for example. I want to discuss now one Aboriginal right in particular that is a matter of great interest at the moment in Canada, and it's the right of self-government. The right of self-government is recognized in the context of modern treaties. So there's about 25 modern treaties, which includes self-government agreements, whereby Indigenous governments, self-governing governments, have powers to govern their internal affairs. But outside the context of these self-government agreements, courts have not yet recognized a constitutional right of self-government for Aboriginal people. The Supreme Court was asked that specific question at the end of the 1990s, and the court refused twice to decide whether the Constitution protected the right of self-government of Aboriginal people. And the question has not been put before the court since that time. But interestingly, despite the lack of judicial decision on the topic, the federal parliament went ahead and enacted a statute that is based on the premise that the right of self-government exists for Aboriginal people. This is the Act respecting First Nations, Inuit, and Métis children, youth, and families. It's a statute that was adopted in 2019, and that concerns specifically the right of self-government in the context of child welfare. Just to give a bit of context around this statute, it was adopted in response to the current crisis in child welfare for Indigenous children in Canada. There is an alarming overrepresentation of Indigenous children in child welfare, and you can see on the slide here some heartbreaking statistics about this crisis. And so, faced with that urgent problem, the federal government undertook consultations with Indigenous groups and organizations, and it was agreed that a reform of child welfare would need to be based on self-government rights of Indigenous people, that Indigenous peoples know what is best for their own children. Parliament enacted this act, and in the Act, Parliament formally recognizes the constitutional right of self-government of Indigenous peoples over child and family services, basically child welfare. The framework of the Act is really unprecedented in Canada. So the Act, as I said, it's based on the assumption that there is a constitutional right of self-government over child welfare. And the Act creates a framework to facilitate the exercise of this presumed constitutional right by Indigenous peoples. So in other words, Indigenous peoples can use the framework of the federal statute to enact their own law on child welfare. And provided that they comply with the conditions set out in the federal legislation, and one of this condition being that the Indigenous groups tries to negotiate with the federal and provincial governments. They don't have to reach an agreement, but they have to show at least reasonable efforts to conclude an agreement. So provided that they comply with these conditions, the Indigenous legislation will prevail over federal and provincial conflicting laws. This is a novel approach in Canada, and it's currently being challenged by the province of Quebec. And I'm also involved in this case. So we were in court in last September, and before the Court of Appeal of the province of Quebec, and we're waiting on a decision. I will take one last minute to end my presentation with a recent challenge to the amendments to the rules of succession to the throne. So Canada is part of the Commonwealth, and its head of state is the Queen and Right of Canada. And in October 2011, the 16 Commonwealth heads of state met in Australia, and they agreed to propose amendments to the rules of succession to the British throne. And following that agreement, Canada adopted the Succession to the Throne Act, which gave Canada's assent to a bill that was introduced in the United Kingdom and that was eventually adopted by the British Parliament to modify the rules of succession. And Canada's legislation was challenged before Canadian courts. The question that was asked to the court was, can Parliament change the rules of succession to the throne without amending Canada's constitution? If not, it would mean that amending the rules of succession would require compliance with the amending procedure of the Constitution, which was not followed in this case. It was simply a federal legislation that had been adopted. So the basic question was, are the rules of succession to the throne parts of Canada's constitution? And the court answered negatively. The rules of succession to the throne are not part of Canada's constitution. What is part of Canada's constitution is the principle of symmetry. So the principle that whoever is king or queen of the United Kingdom is also king or queen of Canada. So Canada could, by sole legislation, give assent to the modification of the rules of succession to the throne. That ends my presentation. I will now turn it over to Stephen for some comments or questions, and I'm eager to hear the parallels that you draw between Canadian and Australian constitutional law. Thank you.
Lindy, you did very well. You actually had an extra 58 seconds to go, so you haven't gone over time at all. I recently had a talk that I was chairing with a survivor of death row who now lives in Ireland, was so passionately involved. I think we had to let her speak for about an hour over time because we just could not interrupt what she was saying. So you've done incredibly well. So to our people online, if you put your hand up, I can call upon you and then you can unmute yourself. For people who have put questions into the chat, and I'm not sure that there's any yet, Kent will tell me what they are and I'll then feed them through to Lindy. So do we have anybody at the moment, Kent?
No, not anybody yet. Anybody in the room? I've got a question.
Could you hear me?
Yeah, I'll repeat it. Yeah.
My question was just that, Linda, you mentioned that the override mechanism is not commonly used at the federal level, but is more, getting increasingly used by the provinces. I was wondering what kind of laws it was being used in regards to.
Lindy, the question is, and it comes from the room here, what are the political imperatives that are driving the provincial legislatures to override the charter in the Constitution? What sorts of issues are the hot button issues to trigger an override?
One of the hot case at the moment is about the use of the notwithstanding clause by the Quebec government in a legislation that aims at recognizing I'm looking for the English word, the religious neutrality of states, and it prohibits the use of any religious signs by any public servants, and the definition of public servants is broad, and it includes teachers in primary and secondary schools. So the Quebec government used the notwithstanding clause to protect its legislation from being reviewed by the courts. The Quebec's legislation is still being challenged before the courts. So, but the court will really have to decide what to do with a statute where the notwithstanding clause has been used. Traditionally, the courts have said that if the notwithstanding clause is used in a statute, that ends the matter. The courts do not look into the constitutionality of the statute and whether it complies with it, infringes on charter rights. But there are some arguments that are suggested at the moment that the court should still look a bit deeper into the reasonability of the legislature using the notwithstanding clause. So it's a current issue. The matter is currently before the Quebec Court of Appeal, but I wouldn't be surprised that it goes to the Supreme Court in the coming years.
Thanks for that, Lindy. Now we have a question from Joseph Morrow, and I might just preface it by the fact that I noticed in having a little bit of a glimpse at the Truchon decision that the national government did call evidence from disability rights activists who are involved professionally in making people with disabilities have maximum opportunity to live a full life. They gave evidence about concern they had about the slippery slope of allowing assisted dying in the case of disability rights people. And the court, I think, dispensed with that evidence fairly quickly. So Joseph's question is, since the decision was handed down, what's happened with regard to the politics of that issue? Are there disability rights spokespeople who are saying that the court went too far and that there are vulnerable people being provided assisted dying when they shouldn't really be provided with assisted dying? Has that issue moved on since the court handed down its decision in any discernible way in the Canadian public?
Yes, so when Parliament studied the 2021 bills, the many organizations representing disabled people voiced their concerns that liberalization of access to medical assistance in dying would put disabled people at risk. It's one of the issue. The Parliament is currently studying some more difficult issues related to medical assistance in dying. For example, the medical assistance in dying for people with sole mental illness, for minors, and also the impact of medical assistance in dying for vulnerable people and people with disability. But after that, the law has been adopted, as I mentioned, with some additional safeguard measures that are aimed at protecting vulnerable people. There are also been some legal challenges in courts before the 2021 legislation and after by individuals who claim that this regime in fact puts them at risk of accessing aid in a moment of distress or weakness, and that in that way it breaches their right to life, liberty, and security, but they were all unsuccessful. And when we read the Carter decision that I mentioned and the Truchon decision, the burden on for these claims is really heavy, since the courts, the Supreme Court in Carter and the Superior Court in Truchon, both recognize that physicians are able to assess capacity, they're able to verify consent, they're able to identify undue pressure. And so all this, the assessment of capacity is sufficient according to the court. The courts, they're sufficient to protect vulnerable individuals. So it's going to be, unless there are new evidence or changes in circumstances, it's going to be difficult for organization representing disabled person to change the state of the law in Canada at the moment, I believe.
Yeah. Any other questions in the room here? Are there any on the board there, Kent?
There aren't.
No, okay, I've got one. You can think of one in the meantime.
One from Nikita's just come up.
Oh, okay.
The greenhouse pollution pricing.
I'll just read it out to me and I'll...
So the Greenhouse Gas Pollution Pricing Act case was about whether there was a head of power to deal with climate change. Are there any cases in Canada where the issue of climate change has come up as a matter of human rights?
That's a good question. So the question is, and it's from Nikki, is that right? Is the case as you discussed it was really about the power under the POG power under the Constitution. The question is, has there been any litigation, constitutional or otherwise, in Canada in which the connection between climate change and its impact on human rights and the protection of human rights in the Constitution, whether that's been litigated in any way?
Yes, it's currently being litigated. There has been some attempts. I know of at least 2 attempts to sue the government for climate changes, particularly by young people, on the basis of a violation of their charter rights. But and so far, plaintiffs have been unsuccessful with these claims. In the first one, Canada was sued for its overall policy, response to climate change, and the court, it was a federal court, a first level court. It concluded that the claim was not justiciable. And it's not possible for courts to review all of the government's actions and inactions in relation to climate change. So judicial review cannot do that. So that's the first case that failed. The second case is interesting because it's a class action. So it's an application for class action in Quebec for Quebec residents of 35 years old or younger, and they seek a court declaration that Canada's inaction towards climate change breached their charter rights. Their application for class action was dismissed in first instance, and the case is currently before the Court of Appeal. So it's a matter that will be decided probably. It was heard by the court, and we're waiting for the decision. Yeah. So.
That's interesting. In Australia, there's a case called Sharma, which has been successful at first instance before a federal court judge, but is under appeal before the full federal court. And it involves a duty of care said to arise out of environmental protection legislation at the federal level. So it's interesting the different ways in which these issues have been raised in the different jurisdictions. I had a question also, sort of a constitutional question about the POG power. It seems to have an advantage that whatever happens to come up as a national issue, you can say it comes under the POG power. In Australia, what's tend to have happened is that the specific heads of power have been reinterpreted and given new meaning over the years. Does that also happen in Canada? The sort of example is that a telegraph power with regard to telegraphs might be interpreted to say, well, that applies to radio and that applies to television and that applies to modern communications. Has the POG power sort of stopped the necessity to reinterpret those sorts of heads of power?
No, I think the court prefers to interpret the heads of power with flexibility before using the POG power. I think the court is very reluctant to use the POG power, so it was used in very limited amount of cases. And we have the same jurisprudence, the same case law about telegraphs and the fact that it can be used for other new technologies. So no, the courts tend to interpret the enumerated heads of powers generously, and there is the idea that comes up in the case law of the Supreme Court very often of the Constitution being a living tree, so it has to adapt to the new circumstances.
Okay, we've got time for one more question, I think. I've got one, but is anybody in the room here? I can't see any on the board. I can't see any hands lifted. Can I ask you, what's the situation with regard to First Nations sovereignty in Canada? In Australia, the prevailing interpretation seems to be that because the sovereign's courts get their power from the sovereign, they can't recognise any other kind of sovereignty. So you have this catch-22. So the issue cannot develop through litigation and consideration of the Constitution by the courts. At least that's the way it's interpreted at the moment. Obviously, in the United States, there's issues of First Nations sovereignty recognised from the treaties. What is the situation in Canadian law with regard to sovereignty of First Nations peoples of various kinds?
The debate in Canada really turns on the right of self-government and not sovereignty so much. I think the courts have assumed that they have power to, because the Aboriginal rights and treaty rights are now in the Constitution, the courts have assumed that they have the power, jurisdiction to decide the extent of these rights, and the courts have seen the constitutional protection of Aboriginal right as a way of reconciling the preoccupation of prior occupation of Aboriginal people in Canada and the sovereignty of the Crown. So this idea of reconciling sovereignty with Aboriginal people is done by the courts through the Constitution in Canada.
Thank
I
you for
wouldn't say that all Aboriginal peoples agree with that approach, though. But this is the approach that is followed in large majority by Canadian courts.
Okay, thank you. Well, can I just say personally to you, thank you very much. I'll get Ken to come up and formally thank you on behalf of our audience, but perhaps the people in the room here, can you show your gratitude to Lindy? I hope that's
Thank you.
through.
Thank you, Lindy and Stephen. On behalf of the Queensland branch of the Australian Association of Constitutional Law, I'd like to thank Lindy and Stephen for speaking and sharing, especially Lindy over in Montreal, staying up so late searching for English words. Thank you very much. And for all the effort you've put in. You've brought us up to speed with the breadth and depth of Canadian constitutional law and brought us right up to the present moment so quickly. That's an amazing work that you've done there. I'm very grateful. I hope this leads to some cross-pollination of ideas between Canada and Australia and some more dialogue between Canada and Australia in forums such as this. So once again, if I could get everyone in this room, because we don't get to meet very often now that we're in COVID days, to give a round of applause for Lindy and to Stephen Kime. Thank you. And with that, we'll close. Thank you very much.
Thank you.